Hello, fellow Toolboxers. Welcome to episode number 324. This one's going to be, and the next bunch of them are going to be interesting because I have a backlog of recordings that I did in last quarter of 2023, first quarter of 2024. I'm sorry, last quarter of 2024. What are the years? And I'm losing my mind. Okay, I was correct at the beginning. Last quarter of 2023, November, December, January, February, those areas that I recorded. And thank you for all the people I interviewed and are waiting for their episode to get out. There's actually more ones from October too. That it's like 10 episode backlog that I'm going to get out. So there's going to be a discontinuity of all these Kevin Gregg episodes as well from November to February that didn't get published. Thank you, Kevin, for hard work and having me sit on him. But we're getting them out now because the info is good. It's a lot of stuff's evergreen. So all this is evergreen. It's from 6 months ago. But it's part of my situation of getting back on the horse and getting business up running now that I get some sleep, frankly. So having said that, the following information is not considered individual legal guidance. Contact an attorney to, the stuff for the non-lawyers listening. I do want to say that as part of the backlog that I have this O1 seminar I did in LA where we had like about 15 people flying from the East Coast. We had the best O1 attorneys in the country talk about it, just how to do an O1 and all that kind of stuff. And it was a pretty excellent session. And I've sat on that recording for 2 years. I haven't edited it. So it's raw footage of like a whole day of like how to, and it's like really insider kind of knowledge. And I want to get it out. So we have a marriage green card course that we have. That's the best in the game. For people purchasing the marriage green card course, you got to contact me. I'm going to have this as like a limited time offer only. But I really want to get these videos out. So I haven't made the full offer of how it's going to be. But if you're interested in a marriage green card course, if you're getting involved in U.S. immigration, you want to learn family-based, this tag-along course for employment-based will be there as well for this specific type of non-immigrant visa. So you get a package that's going to be, double the value for half the price, essentially. Email me at info@immigrationlawyerstoolbox.com. For those who just want to get the O1 itself, email me. And then if I get like 10 people who want it, I'll make some sort of package deal. I'm not really sure yet. I'm trying to get content out. But I just want to let you know that we have the best stuff out there. It's available. Just email me, info@immigrationlawyerstoolbox.com. And we'll figure out a way to get it to you so you can become a better immigration attorney. That's the goal of what we're doing here. I hope you enjoy this one. Hey, Kevin, good to see you again. Great outfit for those listening to audio. Definitely check out the video version on YouTube for the Immigration Lawyer Toolbox. Good to see you.
Good to see you too. For those listening on audio, it is a llama Christmas sweater, and the llama is actually 3D, and it even has a bow. For full effect, I am Jewish, but that doesn't mean I can't wear a Christmas llama sweater because
So,
Christmas is non-denominational. Tell that to certain people, they'll get really upset, but it really is. I mean, Saint Nick has nothing to do, I don't think, with Jesus. At least
pretty much the whole
Santa.
thing is Saturnalia, Roman traditions, Norwegian. It's all pagan stuff, but essentially, other than like one piece of it that they put on there. But
I mean, Saint Nick might be. I actually don't know anything about Saint Nick. It sounds like he's actually probably Christian, but Santa Claus, well, a Jew can celebrate him too, and especially in llama form.
For sure. Well, thanks for coming on. What we got going on cases? I mean, we're covering some December stuff. By the time this gets out, a lot of these are running late, so it's going to be past the new year. But what's going on in the court system? There's a couple of interesting cases that came out.
I can't do the December cases on a December podcast with
Oh, that's
you,
true.
John. I've got
Always
I've got the pattern down. It just wouldn't work. So I mean, we kept pushing this back, and so I'm still doing the November ones, which,
true.
and the courts were a bit quiet in November. I'll have a more interesting one for you maybe next month when I'm doing the December cases, but there's still interesting stuff. A lot of focus on New York and crimmigration in November, at least with the good ones for non-citizens, which I like to do when I come on your show, because I do
Yeah.
all the bad ones on my show as well. But why do them all here? And the first one from the BIA, which I always want to give props to the BIA when I can, when it's going to be a non-citizen good case. It's a matter of Brathwaite, which again, give props to the BIA for a non-citizen good, but really they had to, because this comes on remand from the Second Circuit in this very case in Brathwaite v. Garland from episode 62 of my podcast. So, like, what's the BIA going to do? They've got to follow what the Second Circuit said. But what the
Yeah.
Second Circuit and now the BIA is saying is very important. And, before I get to the holding, the Second Circuit says it, very important if you're in the Second Circuit to this specific New York statute. But when the BIA says it, it's nationwide,
Hmm.
right? and it could apply to other statutes. And now when the BIA says it, as it must, you can use that logic to apply
Interesting.
it to other state statutes. I mean, that's just how it works. And what's happening here is the Second Circuit, before the BIA, well, the BIA analyzed it precedentially, I believe. Maybe in matter of J.M. Acosta, the BIA analyzed it precedentially, and then the Second Circuit came in. It's New York Criminal Penal Law, Section 460.30. And that law, as I understand it, essentially is a late filed criminal appeal in New York. I mean, usually based on, most states in most contexts, you have like 30 days to appeal. Usually. I mean, there's a
Hmm.
million statutes. But this specific New York statute allows for a late filed appeal after, I want to say, a year and a month.
Uh,
And it's a late filed appeal. And the BIA was saying, well, no, I mean, you file a late filed appeal, whatever. The appeals court can accept that appeal, they cannot, but that's not a direct filed appeal. You can still initiate removal proceedings based on a criminal conviction, even if this 460.30 appeal is filed. And the Second Circuit came in and said no. And at least with an accepted late filed appeal, but I'm not even sure that's the holding. With this late filed appeal, a criminal conviction in New York is not final,
hmm.
which, from a practical standpoint, I think means because they can be filed, I think, a year and a month, it would appear that DHS can't initiate removal proceedings based on a New York conviction until it's been like a year and 31 days. I mean, it's pretty wild. And this is some of the rationale that the
Yeah.
board and ICE was arguing. But the Second Circuit came in and said, no, this happens as a matter of course. In New York, we're treating this like a direct appeal. And obviously, if successful, the person doesn't have the conviction, but it's not final because we're treating this as a direct appeal. That's a big deal, for especially for LPRs with criminal convictions and all the things that can happen when you have a year to challenge this on appeal, and maybe you're collaterally doing things at the district court, at the
Yeah.
trial court level. Who knows? But a big deal, matter of Brathwaite. And as I said on the podcast, then what other state criminal appellate law statutes are similar to New York Criminal Penal Law Section 460.30? I mean, you got 50 states. What are the other 49 late filed appeal statutes like? And if they're similar to this, to me, the logic of matter of Brathwaite
Yeah.
would apply, and we should be considering those late filed appeals as making convictions non-final as well. So, immigration is the gift intellectually that is always giving in this time of giving, because there's always, when you're mixing criminal law with immigration law, you've just got the perfect storm of
Yeah. It's a lot
complexity.
of reading. That is.
Right, it's true. It's a lot of reading. And as an immigration lawyer, as the kind of immigration lawyer that likes an intellectual challenge, I love immigration. I know there's a fair amount of IJs who wish it was just simplified, people in the Congress that wish it was just, you know, two misdemeanors or one felony and you're
Yeah.
out. No, it's not the law. That's not what the Supreme Court's created. We've got the categorical approach. We protect due process. And so the arguments are often endless. That doesn't mean they're all meritorious, but you never know what's going to catch. And I think we're seeing that with the deficient NTA case law.
Yeah.
Smart people who were making those arguments getting rejected and rejected for 2 decades, all of a sudden are the savant. They're the savants, right? I mean, I don't even know
Yeah.
who they are, but
And
um,
especially with the makeup of this court, which was kind of unexpected that it will lean this direction.
that's right. We'll see. Now going to the deficient NTA. I mean, yeah, that oral argument I believe is January 4th or January
Wow,
8th
is that
in
soon?
the in absentia motion to reopen deficient NTA case before the Supreme Court. So big hole. If the Supreme Court agrees with literally every circuit to some degree that's
Yeah.
really tackled the issue, then my God, there's I don't know 50,000 in absentia removal orders, 100. Who knows
Yeah.
how many in absentia removal orders are at issue based on deficient NTAs? So, point is, just like that with crimmigration, who would have thought that a late filed appeal that's filed a year and 30 days late is a direct
Yeah.
appeal? But here you go.
Very neat. What else have you got for us?
Starting off small, right?
Yeah.
With New York, more crimmigration. Again, New York's a slow month, and when it's a slow month, sometimes I dip down to the sentence enhancement stuff because it's the same categorical approach. Sometimes it's the same crime of violence definition. But here I've got United States v. Charez by the Second Circuit, which is really just going off U.S. United States v. Minter. Um, and it's about New York cocaine. I think I came on your show and talked about Minter a month or two ago. But in Minter, the Second Circuit said that New York's definition of cocaine is overbroad, such that it can't be a controlled substance offense for sentence enhancement purposes, which I see no reason why that doesn't directly then apply to immigration. It would seem that a New York cocaine conviction, be it trafficking or possession,
Damn.
is nothing for
Yeah.
immigration purposes, and that's huge. But this case, Charas, first of all, it's just explaining how big of a deal US v. Minter was. It seems like the Charas court didn't like it, and that the Charas court might have wanted to get to the issue first, but once Minter was issued, this other panel is so bound, and that's just appellate procedure, which is wild if you're a appellate judge,
Yeah.
who I don't think come on your podcast or mine. But maybe we can ask him if they do
Yeah.
one day. But Charas, when I was reading Charas, it showed me it was even broader than I thought, because the New York penal law that's at issue, it's New York Penal Law Section 220.391. It doesn't actually reference cocaine. Yes, this is all about cocaine, but cocaine is coming in under the statutory term of narcotic drug. So really, the holding of Minter and Charas is that New York's definition of a narcotic drug is overbroad because it indivisibly includes cocaine, which is overbroad. That's even bigger. It would then seem that every New York law that references narcotic is not a controlled substance offense. Because again, narcotic means cocaine and other things, but cocaine is overbroad. So huge deal in New
Yeah.
York. Um,
If that happens in Florida, then that's gonna be a big deal.
why? Because there's a lot of cocaine in Florida. I the argument was made in Florida in Shamu. I think it was cocaine. If not, it was meth or something like that. The isomer argument. And in Shamu, I just think that the chief judge just he just couldn't go that far.
Yeah.
Judge Pryor. But he didn't, as I read Shamu, he didn't preclude the argument. He just said, I don't believe that this isomer of cocaine that you're saying makes it overbroad. I don't believe it exists, even
Mhm.
though they had a great expert and all this stuff. But whatever, to me, Judge Pryor outlined what they need to show next time to prove that the drug exists. So, like, I don't know, get another expert. Prove Shamu to me doesn't mean anything. It just means that you have to prove to the 11th that exists. But the intellectual framework that is that a drug can be internally overbroad. The 11th has already accepted that argument in the Syed decision. They said that Florida marijuana is broader than the federal definition of marijuana because they know what seeds and stems are,
Yeah.
and Florida criminalizes seeds and stems and the feds don't. So just prove to the 11th that this overbroad cocaine isomer exists, and you got your same argument. So the fact that the 11th has already accepted the logic, as has the 7th, the 8th, maybe probably, I mean, certainly the 2nd, that's at least three. And if you include the 11th, the four have accepted the logic, probably more too. And you've got a heck of a situation. The Ninth Circuit actually adopted this logic many years ago, but then immediately went back and vacated the decision before I was practicing. But like, I think it's only a matter of time before the Ninth comes back and
Yeah.
analyzes this, and now it has multiple circuits to say, look, we're not an outlier here. This is happening. So immigration is the great frontier, and so much of it is actually happening not in immigration, but in the sentence enhancement context, with very smart federal public defenders making the argument, but we benefit from it just as much in the
Yeah.
immigration space.
This is highly, highly technical stuff, but yeah, these people,
It is. I don't think
yeah.
anybody knows what an isomer. I mean, you know what an isomer is. No one's ever seen an isomer, but that's not the point.
Well, good stuff. And what else have you got?
Last one, MSC v. Garland out of the First Circuit. Not a non-citizen friendly one, but November was a short month. And I just thought I'd highlight it, as I said on my podcast, because it struck me and it struck other people who had listened to it. It's an adverse credibility, Chinese opposition to family planning,
Hmm.
forced abortion type asylum case out of the first. And the immigration judge and then the BIA found the female, the lead respondent, not credible. And it was for a few reasons. But the main reason was that she then tried to, and I believe succeeded, in having another baby child in America, but never told her doctor in America that she had had this alleged forced abortion in China. And the immigration judge really came down hard, it seems, on her, believing it was just it's unbelievable that someone trying to get pregnant would not tell your doctor about your prior abortions. That was a key component of this adverse cred. And it was affirmed, this whole rationale, by the First Circuit. They said, no, that's not, I don't, the First Circuit didn't like it, but they didn't overturn it.
Hmm.
My mom, who's been listening to the podcast since day one, is a retired labor delivery nurse. And she immediately texted me. I just think it's interesting for people to know that in her career, she had at least, and said it happened all the time. And that people would come in and hadn't told their doctors, hadn't told their nurses about their prior abortions. And there was a million reasons for it, often embarrassment, often trauma. Sometimes they didn't want their current partner to know
Yeah.
about their past. I mean, there are a lot of reasons, and it
Yeah.
can get dangerous. Someone almost died with my mom, um, being one of many nurses on that case because apparently when you've had an abortion in the past, that makes your next pregnancy riskier. And yet
Mm.
still, women routinely don't do this. So I don't
Yeah.
often talk outside the four corners of a decision, but in light of this factual information from my expert mother, I thought it would be interesting to bring up in
Yeah.
MSCV Garland that maybe that rationale isn't so great.
I mean, you see a lot of asylum kind of cases, just all kinds of cases where like USCIS or the agencies come out hard on you for not saying something, but it's like in real people in real life, like things are don't happen like how they would expect. And it's just I see that unfortunately a lot of times USCIS or marriage interviews and stuff where they'll
Yep.
come back bad and they'll pick apart like one thing where it's like, there's really justifiable reasons or just normal reasons why someone would have mentioned this or they get this wrong or something like that and they just pick one thing they threw like the book at it. It's kind of a weird kind of thing that when they pick on something like that.
It can be very frustrating. I think it's sometimes lazy because
Yeah.
like maybe they think there's a lot of reasons, but they can't articulate them great. So they pick on this one because this is the best they
Yeah, I
got.
think
They
that's
don't
it.
want to
Yeah.
say what's behind the scenes, but of course that's not proper. There's a reason we have standards. But I always tell my clients, whether it's immigration court or USCIS or the consulates, really, I just don't have firsthand knowledge of the consulates because we never get to go to the consulates,
Yeah.
right? But I tell them like I assume that the judge, even though it's not always true, I assume that the judge or the USCIS officer doesn't believe you, like
Yeah.
already
Yeah.
thinks that all or many non-citizens are liars. Because people do go to these offices or court and they do lie. It's,
Yeah.
I always assume that that's who we've got. And I tell my clients, like, you've got what, 30, 45 seconds to convince this officer
Yeah.
that you're not one of those people who lie. And if you fail that, maybe even unspoken test, like you might never come back. I think that's incredibly unfortunate. I also think it's a reality, and it's one of the reasons we see these decisions where if you look at the rationales, you can be very taken aback, and it's because a lot of things are happening unwritten, unspoken, un articulated.
Yeah. I'd say it really adds the fact that like we need different perspectives on the bench that they could talk with each other and stuff because we might I mean as guys we might even think about that like in that abortion context it's like it's not something we're directly thinking about in our body and stuff like that but it's important to have context so people better understand it. It just Immigration is so hard. It's so individualized, and it's like it's really about an individual person. It's not some corporate thing or generic kind of thing. And each human being
Yeah.
is so different in how they act. So it's really hard to judge them on it.
Yeah, well, in MSC, you've got the IJ, then the BIA, and then three First Circuit judges who all, and the first didn't love it, just
Yeah,
reading it, but it was all affirmed. So what's what's wrong, what's not? But I'm just telling you what probably the only nurse who read this case,
yeah,
my mother, told you does actually happen, and that it is completely consistent with a woman to not tell their doctor about their prior experiences. So says my mom. She
yeah.
was lying to me throughout my entire childhood. She might have been lying. Now I'm just kidding.
I just think I've had clients who like have serious criminal history and they don't tell me, and I don't think they're lying. They something to forget or they just don't want to think about it sometimes, something, and they just completely forget about it too. And that stuff happens. People could be like that. It's just something that's a negative thing. They just don't want to think about it at all
Yeah,
and act like it never happened, and eventually becomes a reality to them too. So it's not they're necessarily
yeah.
doing misrepresentation. They just forget or it's just a block, a mental block. A lot of people have trauma, have mental blocks on. So
I
yeah,
believe we have a presidential candidate who actually believes some things that are objectively not true. So, it goes up to the highest echelons
yeah.
of a demonstratable videotaped fact. So it goes to everyone.
Speaking of president's politics, when you mentioned the court cases, I was surprised that I kept hearing consistent attorney general names, Garland. And I'm like, oh,
Mm.
remember, it used to like every month there would be a new attorney general, be a different name.
It's right,
Yeah,
right.
so that's some consistency right there. 3 years of that.
You know, Nothing but respect for Attorney General Garland, former Judge Garland, what he did as a prosecutor. He seems, by all accounts, a great
It
guy. But
hasn't been controversial
the
stuff pop up under his reign.
and look, and to indict a former president,
Well,
and
that's, I guess that would
all,
be
I mean,
different.
it's an incredible thing, and he has done this, it seems, with you know, very methodically, and it seems like he
Yeah.
went there dragging. But that being said, he hasn't done anything on immigration. It's very
That's the thing is,
frustrating.
the Attorney General's office of immigration was kind of silent in both directions. Now, he did undo some stuff, a matter of that the last guy, but like essentially he's been silent in immigration. We thought he was going to go other way. It's
Yeah,
kind of
it's very frustrating. I can only imagine it comes from the top that the administration has decided it's not a political winner, or maybe they
yeah.
agree with some of the former attorneys general's decisions. But as I always say, like you mentioned the attorneys general, there were four under Trump, two acting, Whitaker and Rosen. And if they had had their way, it would have been Jeffrey Clark too. And Whitaker and Rosen, definitely Rosen, issued at least three decisions. Those are acting attorneys general who were only there for a couple months. The Trump AGs issued, I believe, about 18 decisions. And so it's just a fact if you have one administration that in 4 years their attorneys general issuing 18 decisions, and then the next administration comes in and doesn't really issue any, then that does something to immigration law. I think that's very frustrating for those of us who don't agree with a lot of the Trump attorneys general's decisions. And again, that administration had no problem with acting attorneys general, not even confirmed by the Senate for that position, issuing presidential decisions. So I do believe Attorney General Garland could do a bit more on that front.
It probably just anything immigration. It's probably the administration thinks politically it's just a negative, so it's not even bothering, I guess, to do something about it. Any aspect it seems so. I mean, there's some stuff that got better, but for the most part, it's pretty weak. It was pretty weak. Even like USCI stuff or procedural stuff. They increased the I-485 form, more public charge questions that don't even make sense. The questions on the I-485, the public charge questions that are on there added. It's kind of a bizarre situation.
Oh yeah, I forgot about that. Our taking away the public charge part of that form, actually, that saved millions of immigration attorney man hours. And yeah, it's not all to the other. And
Yeah.
I've mentioned on the podcast, there's this very confusing argument going on about jurisdiction to review denials of withholding of removal and Convention Against Torture Protection following reinstatement of an order of removal. It's going throughout the circuits, and it does seem that the Office of Immigration Litigation has changed its position and is no longer defending this draconian jurisdiction stripping rule.
Mhm.
And that is a quiet, weird behind the scenes thing that doubtfully happens under the prior administration. So, I don't take for granted that there's a difference in administrations. I guess I wish that no attorneys general were as active as the Trump AGs were, and we
Yeah.
just left this to regular adjudication. But if we have a situation where an administration is coming in issuing 18 presidential decisions, well, we got to think long and hard then about what the next administration should
Yeah.
do.
And they also made big changes to the makeup of the BIA, which stuck. And had there been new appointments in this administration? Has there much shift in that?
There has been one appointment to the BIA, as I understand it, and that appointment replaced an outgoing BIA member. So a net zero at the BIA, and the prior administration expanded the board and packed it. I mean, they
Yeah.
just not
They
even. I
kind
mean,
of retired some
I
people
don't
and keep
agree
on
with
it.
it, but the prior administration
Yeah.
engaged in court packing at the board. There's
Big
just
time. Yeah.
that's just what
Straight up
happened.
court packing. Yeah. And they
And
retired some people too. They give them some packages and moved them around and stuff.
they
Or
did. I'm no expert. I do think that happens in every administration to some degree. I think I could be wrong, but yeah, that's a reality.
yeah.
So, not to say that any of those the BIA members from the last term are, don't know their stuff. I just personally disagree with some of their legal theories, I think. And so there's many ways to read a statute, to read a law, and um I just don't like the idea of expanding and then packing the BIA
Yeah.
just from a
I
procedural
should have got more attention.
standpoint.
Like I think people on both sides like let's not do court packing. Let's try to avoid that kind of stuff.
It's court packing.
Yeah.
That's straight up court
Straight up court
packing.
packing.
That's
Yeah.
what it was.
It was pretty dramatic too. It was a big shit. Like the number went to like from
Yeah,
teens to the 20s or something like that. Or
I don't know the numbers, but yeah,
yeah, it was significant like shift that happened.
yeah. There were a couple retirements, but they expanded the board.
You know. Well, thanks for coming on again. Happy holidays. People will get this a little bit later, but I appreciate it. Any plans for the holiday season? Are you gonna be home or are you traveling?
I'll be home. I'll be wearing this llama at least one more time, probably.
It's a
I'm
good
going
one.
to Seattle for a very interesting interview at the end of the month. But that'll be after the holidays, so it doesn't stop. And I proudly report that I just flew back from Miami and we got a good win and a good individual, and very happy for that
Very
family.
nice.
That's why we do what we do, and it's awesome stuff.
Congrats,
How
bro.
about
Congrats.
yourself? How about yourself? How you doing? What are you doing for the holidays?
I'm doing good. Just trying to get sleep, but sneak in sleep here and there with the little kids and the insanity of that, and just praying New Year brings a full night's sleep with it. That's I'm praying for a New Year.
How 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 little we'll settle for when we get into our late 30s, early 40s.
Yeah, big time. I'm surprised I am sitting up right now, but the body is used to a lot too. It's really interesting. But thanks for coming on the show again, Kevin. I appreciate it, and everything you do.
My pleasure, likewise. Happy New Year, man.
You too, bro. Have a good one.